Today, I'm talking about Elizabeth Wettlaufer, a former Ontario nurse who killed 8 elderly patients and tried to harm 6 others using insulin in long-term care homes. I'm going to focus on how her case connects to Canadian and criminal law. The criminal code sections, actus reus and mens rea, the sentencing, and the goals of the punishment. First, a quick background. Elizabeth Wettlaufer was born in 1967 in Ontario and grew up in a very strict religious household. Her dad was very active in the Baptist church, and there was lots of rules at home about behavior and religion. She was shy, bullied, and realized in high school that she was attracted to girls, but her family and church said this was wrong. She was sent to conversion therapy and even pushed out of religious schools. Later, she studied religious education in college and then switched into nursing program at Conestoga College. She struggled with mental health issues and alcohol abuse. She also developed a strange belief that God was telling her to kill certain patients, as she was the instrument of him. This background helps explain her mindset, but does not excuse her crimes under criminal law. Between 2007 and 2016, while working as a nurse in long-term care homes in Woodstock, London, and Paris, Ontario, Wettlaufer injected elderly or very sick patients with large doses of insulin. Some of them were not even diabetic. In total, she murdered 8 patients, attempted to murder 4 others, and committed 2 aggravated assaults. The crimes were not noticed at first because many victims were old and already ill, so their deaths were treated as natural. The truth only came out when she confessed years later in a treatment program.
It says here at about 9:30?
Yeah.
Run me through.
About 9:30, I gave him a dose of 50 milligrams of insulin. He's not diabetic. So I used a borrowed insulin pen, borrowed insulin, and gave him an insulin shot. And at 3:30, the PSW, throughout the night he was yelling out, "I love you," and "I'm sorry." And not to me, but just you could hear him calling out in his room, and that's what he was calling out.
Mm-hmm.
And then at 3:30, the PSW came to me and said that he was gone. And said that his cause of death was from an embolism due to his post-hip. He'd had hip surgery. Doctor ruled it embolism due to post-hip surgery.
For this assignment, I'm focusing on the main case, the first-degree murder of James or Jim Silcock. James Silcock was 84 years old, a World War II veteran, and living at Crescent Care Nursing Home in Woodstock, Ontario. He was very frail and completely dependent on the staff. On August 11, 2007, Wettlaufer deliberately gave him a large medically unnecessary dose of insulin. He was not a diabetic who needed it that amount. Soon after, he went into insulin shock and died. At the time, his death was treated as natural because of his age and health, and no one realized it was murder until she later confessed. Here's how this murder connects to the Criminal Code of Canada. Section 229 states that murder happens when a person causes someone's death and either means to cause their death or means to cause serious bodily harm they know is likely to cause death. In the Silcock case, Wettlaufer gave a powerful and unnecessary dose of insulin that she knew could kill, so this fits the definition of murder. Section 231 explains first-degree murder. One key part is that it must be planned and deliberate. In this case, she chose Silcock as a victim, used her job to access insulin, gave it on purpose with no medical need, and this shows that planning and deliberate action, not accident or sudden loss of control, was taken. So legally, this is first-degree murder. Murder in Canada is always an indictable offense, never summary or hybrid. That means that it's the most serious level and must go to a higher court. Section 235 of the Criminal Code says that the sentence for murder is life imprisonment. Section 745.1 says that for first-degree murder, the person cannot apply for parole for 25 years. In this case, the actus reus includes that she selected and obtained insulin even though there was no medical order for a large dose for Silcox. She prepared and injected the insulin into him herself, and the dose was medically unnecessary and far too high. This injection directly caused or significantly contributed to his death. So, the physical act and the result is his death, and it's clearly there. For mens rea, as a trained nurse, she knew a large dose of insulin could cause serious harm or death, especially to a frail 84-year-old. She gave the dose of insulin on purpose, and it was not a mistake or mix-up. She later confessed that she wanted patients gone and that she chose people she thought were near death. She also said she believed she was getting messages from God telling her to kill certain patients as an instrument or angel of death. This shows that she understood the consequences, intended to cause death or serious harm that could result in death, and planned it in advance. So both actus reus and mens rea are clearly present. The evidence in this case was strong and came from different sources. Object evidence was medical charts, insulin records, and work schedules showed which patients got insulin and when she was on shift. There was body element evidence from autopsies and medical record reviews that showed insulin overdoses and patterns of unexplained low blood sugar. There was also a witness evidence and her detailed confession to police and statements that she made to the staff at the treatment center, plus people she had told previously. All of this together made it almost impossible for her to deny what she had done. The judge sentenced her to 8 concurrent life sentences for first-degree murder, with no chance of parole for 25 years. The sentences for the attempted murders and aggravated assaults were 10 years and 7 years, and were also concurrent, meaning they were served at the same time as the life sentences. Because of the seriousness of her crimes, it is very unlikely that she will ever be granted parole. In sentencing, judges look at aggravating and mitigating factors. Some aggravating factors in this case were a large number of victims, with 8 dead and 6 harmed. Victims were elderly, weak, and very vulnerable. Huge breach of trust, as she was a nurse and supposed to care for them. The crimes happened over a decade, not just once, and the serious impact on families and public trust in the healthcare system. Some mitigating factors is that she pleaded guilty, which avoided a long, painful trial for the families. She fully confessed, including crimes that might have never been discovered. She had mental health and addiction issues, which helped explain but not excuse her behavior, and she eventually showed some remorse at sentencing. The judge had to balance these aggravating factors and mitigating factors, even though the aggravating factors were extremely strong. Finally, let's connect this to the goals of sentencing in Canadian law from Section 718 of the Criminal Code. Denunciation. The sentence sends a message that society strongly condemns what she did. Killing vulnerable patients as a nurse is seen as one of the worst betrayals of trust, which is the reason why denunciation makes sense as a sentencing goal for this case. Another goal was specific deterrence, keeping her in prison so she cannot hurt anyone again. The general deterrence was warning other healthcare workers that abusing their position will lead to life in prison. Protection of the public is also a goal. By locking her up for life, the court is protecting the public and especially vulnerable seniors from any future risk that she might pose. Retribution. The punishment matches the seriousness of the offense. Taking many lives results in the most serious sentence available, life with no parole, for 25 years. Even though she was an addict to alcohol, rehabilitation was not a major focus here because her long pattern of offenses and they needed to protect the public. Her mental health and addiction were considered, but they didn't reduce the seriousness of her sentence. In conclusion, the Elizabeth Wettlaufer case is a clear example of how Canadian criminal law deals with first-degree murder, especially in a healthcare setting. It shows how the criminal code definitions, actus reus and mens rea, aggravating and mitigating factors, and the goals of sentencing all work together in a real-life case. Thank you for listening to this video for my criminal law assignment, and if you have any questions or want to know any more about this case, let me know.